So thank you very much for joining us for what I think is ICLE's first ever conference in Brussels. It seems amazing that I've been at ICLE for so long and we have never done an event in Brussels. So I'm very glad you could all make it here. So today we've got four great panelists and a moderator to talk about the Commission's review of its both Article 102 guidance and future guidelines. Now, I remember when I started studying competition law, this was a little bit more than 10 years ago, which I guess means I've been doing this for a while now. The talk of the town was how European competition law was going to become more modern, more economic. This was just on the back of the guidance paper that's been amended now. And it seems like since then, things have changed a great deal. The Google search case started, and then all the other digital cases followed. And then there was the big defeat, Intel. And last, the DMA. So all of that is to say that the world of today seems very, very different from the world that existed when I started studying competition law a little bit more than 10 years ago. Hopefully, our four great panelists are going to have interesting things to say about these changes. And before I leave you, I just want to give my own guidelines or guidance to the panelists. And just as the Commission would say, this is not a statement of the law. Number one, let's try and keep our answers short and respond to other people on the panel. Number two, feel free to interrupt your co-panelists in a polite way, in a civil way, but interrupt them if you disagree so we can make the conversation a little bit more interactive. And last but not least, for people in the audience, my final enforcement priority is please raise your hand if you have any questions or any remarks. That will make the conversation more interesting. We'll also have audience Q&A at the end of the panel anyway. And with that, I leave it to Giovanna, our moderator for today.
Hello, everyone. Thank you for joining us. My name is Giovanna Fagionato. I will do my best to facilitate an interactive and lively Q&A. We will discuss the new guidelines the Commission is working on and the new guidance paper published in March. Over the next hour and a half, we will take the last 15 minutes, 20 minutes for the question by the audience. So please exactly raise your hands. First, I would like to exploit the experience of the speaker on my left, because Jean-Francois, you have been practicing competition law for a long time, so probably you are the best.
Years.
So probably you are the best person to tell us a little bit more about the origins of the guidance paper in 2008.
Yes, I think it's important to see this in the context of the revolution that was a real revolution of modernization that took place starting in the mid-90s, which was focused on Article 101. Before the 90s, starting in the 16, the Commission had very cleverly made full advantage of its exclusive power to grant exemptions under Article 85, then 81, now 101, paragraph 3. It had developed a concept of restriction of competition, which was extreme. Any restriction on the freedom of action of a party was a restriction of competition. So, for example, an exclusivity agreement between a manufacturer and a distributor was a restriction of competition because the manufacturer was preventing itself from appointing another distributor. And so then this required an exemption in order to be valid. And the Commission used this power to grant exemptions to exercise what Nicolas Petit, the law professor, I think, correctly described as contractual engineering. So giving exemptions to companies provided that they delete clauses in their contracts that the Commission didn't like, for example, import on export ban in an exclusivity arrangement. And of course, all of this in the context of the creation of the common market. Of course, since the Commission could not exempt every single agreement, then it developed this typically European concept, the block exemption. We were the only ones in the world to do this. So with their list of white clauses, which were okay, black clauses, which were not, and some gray clauses, which were in a kind of limbo. And so we had a competition law under Article 1.1, which looked very much like a law of abusive contractual clauses with lists of clauses, which were fine or not fine, regardless of the market position of the parties. Of course, next to that, there was normal enforcement of cartels, etc. But for, let's say, reasoned, decent agreements, the approach was extremely formalistic. So when people use the expression form-based, it really refers to that time where there was this formalistic approach to restrictive agreements. So in the 90s, the Commission grew tired of this. And also was concerned about the first big enlargement that was looming, and thought that it was spending too much time, in fact, on mostly innocuous agreements. So there was the famous white paper, which led the Commission to abandon its exclusive competence. That was the first time we were seeing an administration doing this, abandoning the notification system, and in fact then adopting an interpretation of paragraph 1, which was more mainstream, more like, for example, the interpretation of section 1 of the Sherman Act. So looking at the effect of the practice, not just at the form of the clause. So this was implemented in 2004 in Regulation 1/2003, right on the day when we had 8 new member states joining on that date. So modernization started with Article 101. There was also modernization, which came about in relatively dramatic circumstances for merger control, which had been introduced in 1990, which was applied in an increasingly stringent way, leading to the annus horribilis of 2002, 3 defeats by the Commission, Ertour, Schneider-Legrand, Tetra-Laval, in the space of 6 months, so 3 merger control decisions annulled by the Court of First Instance, which led the Commission, that was at the time under Commissioner Monti, to disband the merger task force, to exile some of its heads to what was then the Commission Siberia state aid, which caused them to resign and join private practices. It caused also the Commission to change the substance of the regulation in 2004, caused also the Commission to appoint a chief economist, a post which created a lot of trouble for Mrs. Vestager this summer, and in fact create an economic unit within DG Comp. There were economists before, but there was a specific organization. So 101 was modernized, merger control was modernized. What was left was 102. And there were, initially it was not planned to modernize 102, but in the community of economists, there was a lot of criticism of some of the Article 102 decisions and judgments. For example, the Michelin case, especially Michelin 2, which was criticized by economists because it was finding a scale of rebates. These were not fidelity rebates. These were what the Commission called fidelity-inducing rebates. But there was no analysis of the impact of that practice on the market. Also, I was the lawyer of Michelin in that case, there was no complaint by any competitor on the tire business. There was a complaint by a retrader, which was a minor aspect of the case. And even worse, this is mentioned in the judgment of the Court of First Instance. The Commission sent RFI, so request for information, to Michelin's competitors, and none of them found any issue with the scale of rebates. In fact, they told the Commission they were doing the same. So it was really, well, this obsession about rebates, about lower prices charged by dominant company also was the subject of a lot of criticism in the economist community. So I remember well, in 2003, Commission Monti announced that there would be a review of Article 102. At the end of 2005, in December 2005, there was a staff study paper limited to exclusionary rebates, which in fact announced what was to follow, the guidance paper, but it was just a paper which was a subject of consultations, and the question was what would be the next step. In 2006, it was suggested something also might be coming for exploitative abuses, but nothing happened. In fact, nothing was happening at all until September 2008, when Mrs. Cruz, the competition commissioner, made an important announcement at a conference, annual conference of the Fordham Law School in New York City, a place where a number of important announcements have been made. Of course, New York City in September, that's a very nice place in which to be in New York. And so many important speeches have been delivered there. So this was the announcement for the guidance paper.
And why did she announce a guidance paper rather than guidelines?
Well, I think that you are putting the question to the right person, because I was, in fact, chairing the panel at Fordham in which she made that announcement. And we had been told that, well, this panel would have as its keynote speaker Mrs. Cruz, but the topic was kept secret until 1 week before the conference. And we were told is on abuse of dominance. I was also told that after her speech, I should, of course, thank her, etc., and then indicate that she had a very urgent appointment and she would leave immediately and take no questions. Okay, so I'm there and sitting at the table, and there is the lectern where Mrs. Cruz makes a speech. And then she goes back to the table and sits next to me on my left. And then I say, oh, well, very interesting speech. So the good news is that we are now going to have guidelines. At that point, really, she grabs my arm, squeezes it and says, no, not guidelines, guidance. I say, well, the good news is now that we are going to have guidance on Article 102. And I thought, gee, I must have touched a very sensitive chord. You know, how much time has been spent on the selection of that word, guidance, instead of guidelines. And then, of course, when the paper was issued in December, it was clear. Guidelines are soft law, not binding on national authorities or courts, of course, but still very persuasive, but binding on the Commission. And the guidance paper was meant to be less than that. It was meant to be no law at all. The excuse is that it would only be used to determine whether a case was meeting the Commission's enforcement priorities, but it was not intended, as Dirk mentioned to be a statement of the law, jokingly, I guess, a statement of the law. It was meant, in fact, not to count, and the purpose was to make economic analysis not judicially reviewable. And the fact that this was really the purpose is illustrated by the case that came out a few months later, Intel, the Intel decision, which is a very long decision, 400 pages, in which you have a middle part of 150 pages of economic analysis, including AC tests, which is referred to in the decision as not being part of the legal reasoning, being just there to show that the case is consistent with the Commission's priorities, enforcement priorities, but not meant to be analyzed legally and not meant to be judicially reviewed. And this worked at the court, at the general court level, which dismissed every single argument presented by Intel, including those related to the economic analysis in this middle section, which was like a bonus to the decision, where the court, and here I have to go into some technicality, a legal technicality, when a court reviews a part of a decision which, well, doesn't count, it can do that in French, à titre surabondant. In English, it's translated in a bit misleading way, for the sake of completeness. So which means that it doesn't count legally, but they do it for the sake of completeness. And so the general court did, for the sake of completeness, analysis of the economic section of the decision. But when they arrived at the AC tests, the calculations made by the Commission, at that point, the general court says, well, we don't even have to conduct for the sake of completeness analysis, because anyway, this is not part of the decision. So they stopped really at the edge of the abyss. I was told by people in the know that apparently there was a section on the AEC analysis in the draft judgment, but the judges found that it was so unconvincing that they decided it was better to delete it. And so that was the missing part of that judgment. So the case goes to the Court of Justice, a very encouraging opinion by Advocate General Val, but then the court, what a surprise. The court, the Commission's main argument is that Hoffmann-La Roche had decided the issue exclusivity rebates by a dominant company are illegal per se. Now, the court refers to that judgment, but then, and I've never seen a judgment like that, it says, but when the company presents evidence during the administrative procedure showing that there is no foreclosure, the Commission is required to engage. And this corresponded to what had happened in the Microsoft case, in the Intel case, sorry, in the Intel case. There had been a lot of interactions between Intel's economists and the Commission's economists. I mean, they played those games. The AC test was suggested by Mr. Shapiro on Intel's side, and the Commission's economists also played those AC games. And of course, they could play those games with a lot of confidence because they'd been told, I guess, that it would not count. It would not be judicially reviewable. But now at the highest level, the Court of Justice says, no, no, you have to engage and you have to address these arguments. And the court then, for me, paragraph 139 of the judgment is very important. It's a list of factors that must be considered. And it corresponds exactly with to paragraph 20 of the guidance paper. And then, of course, this should have resulted in the Court of Justice annulling the decision, because the decision very clearly did not include any economic analysis. but the court decided that the annulment of the decision should be done by the General Court. And so the Court of Justice blamed the General Court for not having included the AEC arguments, Intel's AEC's objections, in its, for the sake of completeness, à titre surabondant analysis, and annuls the General Court judgment and sends it back to the General Court, which annulled the Commission decision. What else could they do? They annulled it on the ground that it did not contain an economic analysis. Then, to be sure, since the court seemed to not to stop on that issue and also was interested in the substance, they found that there were major errors in the AEC test. And of course, they found that the Commission in 2009 did not correctly apply some of the criteria set out by the Court of Justice in paragraph 139 of its 2017, 8 years later, judgment. So 3 pillars. And the strange thing is that the Commission then challenged this judgment, but only on the 2 substantive pillars, not the first one, the procedural one, which in my view makes this appeal very questionable, probably inadmissible. We'll know in a few months. But so
the guidance, I mean, it's started to work from
so,
the very beginning.
Right. So the irony is that, and I will stop with this, the guidance paper, which was meant to be something which is less than a guideline, has been transmuted by the court into the hardest of hard law, case law. And the Intel judgment refers to paragraph 20 of the guidance paper. And in the I think Unilever judgment, there is a reference to paragraph 36. So the court has seen no difference between whether you call it guidance or guidelines. It has seen it as, well, sensible ideas coming from the Commission and worse.
Now we can ask to, yes, please. And after we can ask to the representative of DigiComp why.
Right. So thank
Guidance
you,
and guidelines are
Jean-François, for that extremely thorough rundown of the whole background to the 2008 guidance paper. I was going back and looking at the history of it, and have to say I arrived in Brussels in 1993, so you have a bit more of a track record in this than I do. But you know, if you look back, it really did all start, I think, with Mario Monti, and you see hints of this in speeches from him starting in around 2000. And it is true that by, you know, the time the reform on the 101 guidelines was done and the revamp of the merger regulation in 2004, Article 102 was kind of hanging out there and left over, and no one had really started to do any work on it. And there are some articles at the time where it's talking about Article 102 as the last frontier, or the last of the steam-powered trains that still needed something done about it, so to speak. And in fact, it was the first chief economist, Roller, who commissioned a study from the European Advisory Group on competition policy, on essentially asking them, how do we bring Article 102 more into line with modern economic thinking? And their report was actually very interesting because they advocated the effects-based approach. And they also said that in all cases for 101, we should balance anti-competitive effects against pro-competitive effects. So definitely look at efficiencies. And interestingly, and of course, this didn't survive the whole reform process. They said they renounced the idea that you needed a separate assessment of dominance, if you remember that.
Yeah.
So we don't need to look at dominance. We should just look at the conduct's individual effects on competition. That's quite a radical idea. And of course, it didn't survive in the end, but it was there. And then the November 2005 staff discussion paper was actually a very lengthy document and had an awful lot in it. And when you look at what survived into the December 2008 guidance paper, is actually very little. It's a much shorter document. And of course, you know, the big reason why the guidance paper had to be a guidance paper was that the commission really did want to steer a course towards an effects-based approach. And the case law from before wasn't in line with that. But it was, I think, at the time, quite a bold move. It was a bit, perhaps a slightly risky move, but eventually everyone got on board with it in Luxembourg. And what we have today is kind of 15 years later, the result of that, if you like, the guidance paper was, let's go in this direction now, and please would you all follow us? And that's actually what I think has happened in a very broad sense.
Maybe,
yeah.
and indeed, I mean, the fact that this was called guidance rather than was a compromise between, there were two camps, and of course the legal service hated the idea of economic analysis. It's much easier to defend the case based on Hoffmann-La-Roche than
absolutely.
having to defend very complex calculations. Well, at the end of the day, well, it worked. It worked.
Yeah.
The court looked through the pretense, and so this is a kind of new thinking on the part of the commission. And I've always resisted this idea. Oh, you have the case law of the court. With this case law, it's the court upholding commission decisions. So it's really a mirror. In which the
that's right.
Can see the reflection of its past.
And actually, if you look at the case law of the court on 102 prior to that guidance paper, did the commission lose any of those cases?
No. No, the last time they lost a case on substantive grounds was in 1979, the Hugin case.
Yes.
Which was one of my cases. And I had hoped that I would see, before I disappear from this world, a Court of Justice judgment annulling, or General Court judgment annulling an Article 102 decision. So I'm glad that I saw it in my lifetime.
I mean, the guidance paper was heavily criticized in some camps when it came out. There was some academic literature which seemed to suggest, when I had another look at it, that probably the commission wouldn't apply its own guidance paper because it would be easy to follow these court judgments because they actually had to do less work to get a good result. And of course, that turned out not to be the case. It was also criticized because it didn't include any safe harbors, as if to say it really should have been a block exemption. But it wasn't, for all the reasons we just talked about. And anyway, I think I can perhaps hand over the microphone to you. Did you?
No, I think we can
now we can
go back to the future and go back to the present. And I mean, I would like to ask you, Johannes, if you can explain what are the main reasons the Commission is working on new guidelines and publish a new guidance paper.
Yeah, of course. I mean, when you say the Commission, obviously, I have to make this disclaimer. What I say here is my personal view, not necessarily the Commission. But I very much enjoyed the discussion and how things evolve deeper into adoption. But as you say, now is a bit of a different time. And you're asking for the reasons. You're asking for the reasons. And I think one point that has led the Commission to reconsider the guidance paper and to work on guidelines is that the case law of the Court of Justice has also further developed. And since 2008, a number of judgments have been delivered by the Court of Justice. They're also referred to in this policy brief. It's 27 decisions by the Commission and 32 judgments by the courts. I think that's significant. And that, and especially the case law of the court and also the decisional practice by the Commission on the basis of those judgments has further evolved, and there has been experience gained, and that showed that the guidance paper was a little bit out of sync with the court judgments and what the court has said on certain practices. And just to touch base on a number of areas that also show the background to the targeted changes that were made in March this year. You have the case law on margin squeeze, Telia Sonera, Slovak Telecom, predation, selective price cutting, post-Denmark, rebates. You mentioned Intel, but there's also post-Denmark too. Then more recently, Unilever, Google, Android, and Qualcomm. These are general court decisions. Self-preferencing as something that has been also picked up by the court, the general court in Google Shopping, and then also tying new case law to some extent in Google Android. So these are developments that you cannot ignore. And when the guidance paper is out there and you realize that it's out of sync, then also for the purpose of transparency and good administration, I think it's a wise decision to change these parts. At the same time, there are more, you can only make certain changes and amendments, and at some point you also have to take stock of the whole case law, and that's more for the guidelines. But aside from these developments in the case law and also the Commission's experience and case practice, we also have to take into account that markets have become increasingly concentrated. There's again a reference in the policy brief to some studies, the International Monetary Fund. There you can find those references in the policy brief. And that also needs to be taken into account. And especially with digital markets, I think since 2008, so much has happened. And when it comes to digital markets, we see some specificities and characteristics of digital markets that need to be taken into account. Network effects, the risk of tipping, and all of this shows that under enforcement has to some extent become more costly, and it might also be even more likely. And therefore, it's important to take stock of what the case law has said, take into account developments in the markets, and then go ahead with guidelines that the Commission is currently working on, while making targeted changes to the guidance paper that is by now out of sync with the case law of the Court of Justice.
Can I ask, just not to preempt the moderator, but what are we supposed to take from the specific suggested edits to the guidance paper? Based on what you said, you, I think, would expect considerably more editing than there is. You call it targeted, but it's really just very minor. And I think you listed all of the cases and topics that are, subsequently relevant. I don't think most of them are mentioned in the edits. So I'm just curious then, I guess, what is the expectation supposed to be that the guidelines will be considerably more robust in terms of providing real guidance as to how the court will implement all of these all of these decisions? Because I don't think correct me, maybe others disagree, but I don't think you could say that the proposed edits to the guidance paper are doing any of that.
No, I think it's a fair point that these are targeted and you consider them small changes to the guidance paper. But you have to, I don't want to go into the technicalities of it, but you have a communication and then you have the annex, which makes the changes. The communication really sets the scene and provides the context. And then you have the annex, which makes the 5 targeted changes. And these are to some extent, even though they're small in scope, they have a significant effect on the guidance paper. Take, for example, the notion of anti-competitive foreclosure. I mean, that is a change, which is a minor change if you look at it. But then at the same time, that is a concept that underlies the guidance paper to some extent, and it has been out of sync with the developments in the courts, and that is also explained in the policy brief in more detail. So that gives you even more. So if you're looking for the references to the cases I just explained, you will find them there. But it's really the notion, for example, that it's enough to show the capability to produce anti-competitive effects, that you need to look at also other competitive parameters, not only price. And I think that comes out very clearly from the case law. And those are changes. Then the notion of the as efficient competitor principle, I mean, that is something that the case law, where the case law has developed, and also more fundamentally on principles. And then you have some tiny changes. I agree, where it's really a clarification, for example, that you don't have to show indispensability in margin squeeze, and margin squeeze is a new type of abuse, and that was just clearly out of sync with the Court of Justice
So,
judgments.
is it correct to say that these amendments are a sort of sense of urgency response? Because, you felt that you were not updated with the realities of the market, and
I would say not urgent, but very targeted to make the main changes. I mean, obviously, there's more to take from all these judgments, 32 judgments, 27 commission decisions. There's much more to it. Also, commission experiences that's behind these decisions. So that obviously now invites the commission to take full stock of it. But at the same time, you cannot leave the guidance paper unchanged when you see, that it's clearly out of sync.
Yeah, I think, please, I think if you haven't already seen it on the DG Comp website, it's worth downloading the marked up version of the 2008 guidance paper, which has red track changes for the new bits in it. When you just flick through that, especially if you print it out in color, you see that actually it doesn't look like very much has changed. But what we've now got is a guidance paper which is not wrong, in the sense of it's no longer out of sync with the case law that's happened in the last 15 years. And some of the changes are extremely nuanced. If you just look at, for example, the amendments to paragraph 23, so that you're talking about intervention generally when conduct concerned has already been or is capable of hampering as efficient competitors. That's a very tiny change. And it was already clear anyway in the original version that you could intervene still when there are less efficient competitors. It's just a tiny tweak, but it does something. So, I mean, we also need to bear in mind that there's been a commitment given that the Commission is planning to have new guidelines by the end of 2025. So we're kind of in a bit of a holding pattern while, those get organized. And this is not forever. So.
I would like to know if you can tell us if you think that digital markets require stricter rules or different rules, because I suppose that what you were saying before, discussing with Johannes, do you think that we need stricter rules?
Well, no, but
No.
that's, but I guess one of the many things that puzzle me about the guidance paper and the policy paper, the marked up guidance paper and the policy paper, are how much they are really focused on, partly because they're led that way by the 2008 guidance on pricing effects, right? Which are far less relevant in digital markets. And it's one of the things that sort of relates to the question I asked you before that puzzles me, is why there isn't an effort in some of what we've seen so far. Maybe it's going to happen in the guidelines 2.5 years from now, a little over 2 years from now, but that seems strange not to provide any suggestion of that as to why there isn't more discussion of how you might apply these constraints that have been placed on the Commission from the court in the pricing context in non-pricing contexts. A lot of what seems to me to be happening here is trying to very much to cabin what the courts have said, what the court has said, to very specific pricing focused harms, right? Rebates very narrowly, or and try to escape, ironically, the import of those decisions for many cases, for cases that are maybe the most important cases that are sort of pending right now. The opposite of what you were suggesting, Johannes, right? Not looking at what the cases have said and saying, well, oh, let's update and incorporate that. But some of the language is really, let's look at what the cases said and make clear that we interpret them as being very narrow, specifically focused on, for example, pricing harms. And we are not going to agree with anyone who says these cases impose any kind of additional restrictions on us in the vast majority of digital cases, despite making reference to Google Shopping and other cases, of course.
I mean, one comment perhaps there is that the notion of anti-competitive foreclosure has been tweaked to include parameters of competition such as price, production, innovation, variety or quality of goods and services. And that's directly from Google Android, but only in the general court, of course. Yeah. And of course, that's still got a way to run. So, and also, I suppose my feeling from having read the changes to the guidance paper and the explanation of what the Commission is now planning to do is that Johannes, correct me if I'm wrong, but the point of what was done in March to the existing guidance paper was really just to correct what was wrong within the structure of the existing guidance paper rather than embark on a whole very detailed discussion, and that's going to come later in the guidelines. So you might have wanted to see more now, but we're going to have to wait. And of course, too, it's a good thing that you know, we're now going to go through a process of public consultation and various drafts, and probably lots more conferences like this to come out with something at the end where, you know, an awful lot of information has been fed into the process.
Concerning the the changes, the tweaks in the in this correction that was recently, there is one, in fact, which relates to an aspect of the Intel case, which is the concept of contestable share, and there I agree that this is a concept which needs to be analyzed further, because in fact that's the only thing which is not really AEC in the AEC test for exclusivity rebates, because it's not information that is available to the dominant company. It's information about the share of the customer or the customer's demand that could be shifted to competitor or competitors, something of course which dominant company can only guess, something that maybe even the customer does not know itself, because it may depend on the price. And so, and this caused a lot of trouble for DG Comp in the Intel case. And I agree that this is one aspect of the AEC test which should be looked at further. Maybe there should be a presumption or some formula, because otherwise it's the theory of harm which is reflected in that AEC test is very sound. It's much better than what there was before the time of Michelin 1 and 2, the idea that those rebates, these were yearly rebates, put a lot of pressure on the customers to buy exclusively from the dominant company, especially at the end of the year, as if the customers were so stupid they could not compute an average, and then they would wake up on the 1st of December, say, gee, only 30 days left before the end of the year, so I only buy Michelin tires now, which was a ridiculous theory of harm. The concept was not used of theory of harm to describe this reasoning, but that was the reasoning. So the AEC test is a much more clever approach, economic approach to the issue of rebates, which are a form of leveraging. But I agree that the contestable share, that's the weakness of the test for rebates, but that could be fixed. It does not mean that you just throw away the AEC test in its entirety, which seems to be the suggestion, not so subtle perhaps, in these tweaks.
Yeah, I just wanted to reply to very quickly also in terms of procedure. I think it's a very fair point. The guidelines initiatives now allows the commission to take full stock of the case law and also stakeholder views. And that's why next year there will be a public consultation on draft guidelines. And we see already now an interest in this initiative. When the call for evidence was launched, there were almost approximately 50 replies. And I mean, obviously stakeholders like to comment on all kinds of things related to Article 102. It was not confined to the initiative as such. They also commented on the guidance paper and what it implied. So there was already some interest there, and I'm sure next year when the public consultation takes place, there will be equally interest among stakeholders, and that allows the Commission then to look at that. And coming back to the original point, Jean-François, when you discussed the backgrounds and how it evolved in 101 first with the effects-based approach and the new vertical guidelines in 1999 and so on, I think it's striking that there are no guidelines at the moment for Article 102, whereas for Article 101 we have had the experience with guidelines, horizontal, vertical, for so long. So it's also now filling a gap. That's the idea of this exercise as well, because there is a sufficient number of cases, be it at the Commission level and the court level, to allow the Commission to give these guidelines.
I mean,
so that's the idea in terms of process.
It's going to be, in fact, 25 years from the time we had the first 101 guidelines by the time we get the first 102 guideline. It's a quarter of a century. That's a long time.
Does everybody think that new guidelines are needed?
Absolutely.
Okay, perfect.
No,
No, no?
we
Why?
don't have them in, I'm not that the US is the end all be all, but we've had merger guidelines since 1968. And I don't think we've ever had, correct me if I'm wrong, any kind of monopolization guidelines. Again, I'm not saying that they're, the US is inherently perfect, but it seems to function okay. It's functioned okay in Europe as well. I'm not adverse to guidelines. I just the idea that they're necessary doesn't seem plausible.
Well, we have them, but we need to change the label to elevate them to guidelines instead of this strange guidance. So
And make-
that's
and
one
make-
change.
Make them more
need to do.
detailed, make them more detailed. I think, I mean, they play a very big role for private practitioners in being able to do self-assessment for their clients. And that was one of the criticisms that was leveled at the guidance paper back in 2008, 2009, was that what a private practitioner is supposed to do, what a company is supposed to do.
Yes, that's right, because otherwise the advice given on the basis of the practice, Commission's practice and the case law was so terrible that, you wouldn't want to give it to a client. We would commit suicide to receiving it. And so the guidance provided a way of, providing more helpful advice.
I think there's an inherent conflict though between what the Commission wants to do in terms of providing that kind of advice to attorneys and to companies, and the ever-present effort by every enforcement agency to escape as much as reasonably possible any kind of constraints that are being placed on them by the courts. And I don't think it's coincidence that you have this happening following Intel and Qualcomm and Unilever and a cynic, of which I am one, would say, I mean, really the underlying impetus here is all of a sudden the court is smacking us down and sometimes relying on our own words to do it. We better change our own words to stop that from happening. You don't say that out loud. Out loud, you say, we're trying to provide guidance for everyone. And I totally admit it's a cynical perspective. I'm not saying it's the totality of it, but.
I can ask a bit. I guess it's for the panel side. Isn't there a contradiction if the goal of the guidance is to help practitioners give advice to their clients about what they should and shouldn't do? I put myself in the shoes of, say, Google and Google search, or you can name other cases. Like, I don't know what the guidance paper, in what way it would have helped Google make the self-assessment. And so I guess it goes to Jeff's point. Shouldn't there be then a section, if that really is a goal, shouldn't there be a section on digital markets?
I think that's similar to the question I asked, and the answer, as I understand it, was well, guidelines in 2025 may well do that, right? I mean, at least we don't know that they wouldn't. What we do know is that the amendments to the guidance paper don't accomplish that. But I think Johannes was saying that that wasn't their intention. That was, this was some targeted changes. Maybe you would even say not all of them inherently aimed at providing additional clarity. And perhaps that will come in with guidelines. But you're right, Dirk, that there's very little here that is providing more guidance to practitioners.
Can we have a short answer, I mean, from each panelist about the amendments of the guidance paper? The commission got the amendments right? Yes, no, why? No.
No, I think that they were not really necessary. The only change, as I said, which would be really to elevate this guidance to guidelines. But I'm a bit concerned about what might be coming in the new version of the guidelines. And it's true, as Geoffrey mentioned, last year looked a bit like 2002. Which was terrible for merger control last year. There were 3 cases where the commission lost on rebates. Intel, Qualcomm, and that was a minor aspect of Google Android, but it was again a finding of illegal exclusive rebates that was annulled. So I am concerned that maybe the new guidelines will be designed in such a way as to deal with those defeats. Now, concerning the role of guidelines, in our system, I think they are very useful because we have a system where you have the commission at the top, and then you have the member states. And it's very important also for the commission, for DG COM, to know what kind of rules it is supposed to apply, and even more important also for the member states to make sure that the law, the EU law that they apply is consistent throughout the EU.
And it's also important for national courts, of course, in applying EU treaty provisions.
And about the amendments?
I mean, I think we have to look upon the amendments to the guidance paper as a very limited exercise. And there have been some amendments so that the case law that's happened in the last 15 years is reflected where it has overridden what was originally in the guidelines. And it's a limited exercise, and something bigger is coming.
I think the biggest problem I have, subject to what we've been saying, maybe we shouldn't read too much into the amendments we've seen so far, but the policy paper does this too. I think there's a real either lost opportunity, or again, as a cynic, it's what's intended, to leave open way too much, to maintain so much uncertainty around the effects-based question and the question of whether I wrote down all of the different words, right? Identification of likely consumer harm, allowing a dominant firm to benefit at the expense of consumers, liable to lead to a weakening of competition. That's the language from Google Shopping. So what the policy paper says ultimately is that the wording that appears to be the most suitable to capture such standard is that of potential effects. And what I think is most significant here, and there were some edits, right, that was one of the things that was edited in the or amended in the guidance paper that we've had so far. But what seems particularly interesting to me is that the implication of the discussion, especially in the policy paper, is we need to provide some clarification that we mean something more than pure speculation, and we mean something less than absolute certainty, especially in particular considering potential competitors, potential entrants, whatever. As if anything in between is all the same. that as long as you're not falling prey to one of those two extremes, you know, they're all just synonyms. They all mean the same thing in between. I think that's clearly incorrect. I mean, in a really substantial way. I agree with the notion that we should clarify those boundaries, right? But I worry, even if there's guidelines to come later, that the language that's sort of and the way it's being interpreted now is that we've done enough to try to explain what is meant by an effects-based analysis, including kind of neutralizing is not the right word, but providing a very loose interpretation of Intel and Qualcomm. I don't think that's, I mean, in that regard, I don't think it's helpful at all. Well, I shouldn't say at all. I think it's helpful to define those endpoints, but that's not where the real cases lie, right?
Do you want to
That's obviously
reply?
you.
No worries. No, I think you've touched upon a couple of points which I would like to comment on. So first of all, this was an exercise about transparency and targeted changes again. So I mean, clearly there's more work to be done. I think that's fair to say. Then you've mentioned another dimension of guidelines, which is their impact on the work of the national competition authorities and national courts. I think that's something, I think this is a unique feature here in the EU, where NCAs, national competition authorities, enforce in parallel with the Commission, the Article 102. So that is meant to give guidance also to them and to provide a framework of enforcement of Article 102. Then the other dimension is to give guidance to companies to self-assess. And there I agree there is maybe some degree of uncertainty inherent in guidelines, but that also comes from the fact that they are built on the case law, and the case law also uses sometimes different terminology. So I think the value of the guidelines is really something that allows the Commission to take stock and systematize the case law. For example, to clarify that, for example, we're talking about potential effects. So the notion of capability to produce anti-competitive effects is essentially like analyzing potential effects. So it's a way to give more guidance and to take stock of what the court has said in the past. And then I find it a bit to say now the Commission has never lost a case and now the Commission has lost all the cases. I think that there's a bit, you talk about gray area in between. I think that's also true for that statement. And obviously for guidelines, there's always a risk. I mean, I've also worked on the vertical guidelines before. There's always a risk that the court comes and says and interprets something a little bit differently. And that is true for the guidelines, but that allows then the Commission to further develop and take, I mean, this idea of guidelines is not a one-time exercise. I think it's in who knows, in 25 years, we'll discuss how the guidelines might need an update because the court cases and the judgments have further developed. And another point is something like self-preferencing also is an abuse that was not really provided for in the guidelines as something set out very specific. But I mean, there needs to be also, ultimately, we're enforcing Article 102. There needs to be a possibility to tackle new types of abuses that do not fit so neatly in these categories that we've seen before, but that also ultimately apply to an abuse, especially when the court tells us that's the case.
Just a quick question for everyone, but I don't mean to put you on the spot, you know this, but what's the pressing demand for a sort of self-preferencing analysis when you have the DMA that makes it an outright offense? You could answer in part, right? There could be self-preferencing outside of the context of what the DMA is relevant to, but I mean, those examples would have to be very few and far between. That's where they've all come up. I mean, it's not to say that you shouldn't say something, you know, shouldn't clarify where needed, but are we to expect a huge amount of enforcement in that area from the Commission under 102 when you have the DMA?
Well, first of all, I think partially you already answered your question by saying that, I mean, this is the DMA, it's regulation or a regulatory type of instrument that comes in addition to 102. So the guidelines is really about 102, and that they have different purposes to that extent. And then you're raising another question, which is a very practical one. What type of instruments do you use to tackle a certain issue that you see in the market? And that's a fair and practical question. But if we're talking about the 102 guidelines, I think they should focus on 102 and how it should be enforced based on the case law.
I think it was interesting. I wasn't in Florence at the end of last week for the big IBA competition conference, but Olivier Garçon did come out and say, we're not going to see less antitrust enforcement in the digital sphere just because of the DMA. And I mean, it stands to reason because the DMA only designates a very limited number of companies and platforms, doesn't it? So
He said
I mean-
that the DMA is not the end of the antitrust enforcement. On the contrary, it's the beginning of another kind of
that's
enforcement.
exactly what he said. I think you even wrote the Politico story that I read
Yes.
about it. Yeah.
So, yeah. But if you want, I mean, another question is how, I mean, what are the implications of the Digital Markets Act on the future guidelines? We can anticipate this topic.
Yeah, as I said, I think the 102 guidelines are really about Article 102, and the DMA is a different instrument. So it's really for the DMA then to fully kick in. And the Article 102 guidelines, obviously there's an overlap. And I'm sure that stakeholders will mention this next year when the public consultation takes place. But at the moment, it's I think a similar question that we've received also in reply to the call for evidence was, what about exploitative abuses? I mean, that's something. So in that sense, the initiative at the moment is very targeted. It's about Article 102 and exclusionary abuses. And of course, you may see cases where the question arises, is this an exclusionary abuse or an exploitative abuse, just as is this conduct something worth tackling with, or does it fall under the DMA obligations, or is it something for Article 102 for the Commission to enforce? I think there are so many overlaps, and you need to clarify to some extent the relationship with other regulations and areas, but the focus is Article 102 and exclusionary abuses, because there we have the case law. I've mentioned the number of judgments that really provides a good basis for taking stock of writing these guidelines.
So first issue cases, what cases do you think are going to influence more the new guidelines, or should influence more the guidelines? It's not only for you, this question, I mean, also for the other panelists, but yeah, we can name some cases in particular.
Well, if your question is which ones are going to influence it and which ones are not going to influence it, to come back to the point about exploitative
Or
versus,
should.
to come back to the point about exploitative versus exclusionary, we've headed down this track of exclusionary. But when I was first taught about Article then 86, then 82, now 102, I was taught that the abuses fell into two categories: exploitative and exclusionary. And so I suppose, I mean, a question that we can discuss is what happened to the excessive pricing cases? And they haven't totally gone away, in the sense that we are seeing a little bit of enforcement in that area from some national competition authorities. And I thought, it's quite interesting if you look at the excessive drug pricing cases that the CMA has been running over the last several years. The European Commission actually intervened in one of those cases that got to the Court of Appeal in London in 2019, exactly on the issue of the two-pronged test in United Brands on excessive pricing. And so the Commission very much was concerned about the interpretation of that and in determining excessive pricing cases, even though there are very few of those cases taken, and it's not a priority of the commission to do it. They still do exist. It's hard to show. You'd have to do a lot of economic work on them, and the CMA has learned the hard way with all of those cases. But it's a little bit of a paradox, if you like, that sort of exploitative cases got excluded. We just talk about exclusionary abuses.
Well, I mean, the exploitative abuse cases fell by the wayside. Well, there is the United Branch case, which was my first case, where, in fact, at the time, which bears some similarities with this one, a time of high inflation. After the 30 glorious years after the end of the war, then suddenly there was economic crisis and there was inflation, a lot of inflation. And so there was a discussion among competition authorities about using competition law to deal with inflation. And this even produced a paper, an OECD paper, which is still around. Giving advice on how to do this. And there was great interest in this in Germany. So the attempt to find comparable markets, the concept of as op, but perhaps as if competition, etc. But then, of course, United Brands, the finding of excessive pricing was annulled by the court. What is left is this two-pronged test. But the problem with the case law is that the case law, it's simply the court upholding or addressing a case based on a certain approach. And it just happened that in the United Branch case, the finding of excessive pricing was based on a claim of excessive profits. The court said you did not prove this. And then a comparison with unbranded bananas and bananas sold by companies other than United Brands. And so that's where this test comes from. But if the case had been based on a different approach, you would have had a different case law. So this is why you have to be careful with the case law. Sometimes it's really very fact specific. But there were other types of exploitative practices. We'll take the Sabam case, copyright societies imposing unfair conditions on their members. So there were a whole series of cases which could be characterized as exploitative in the 70s, 80s, and then interest in those cases disappear, or there were less complaints or whatever. And the commission focused on exclusionary abuses, but at member state level, member states have continued to handle exploitative abuse cases. And I guess that if there are guidelines on exclusionary abuses, there should also be guidelines on exploitative abuses, though the problem there is that you are dealing with concepts of unfairness.
Right.
This
is what I was going to say. Is the explanation not a focus on economics? I mean, there was the period you described where I don't know if it lines perfectly with the decline in exploitative abuse cases, but it's, I mean, the economic justification for those cases is very difficult to make, and like you said, Jean-Francois, one reason we're talking about them now is because we're in this high inflationary period. I don't think anyone really thinks that's an economic thing. It's a political thing, and maybe you can use antitrust to do that. Well, so then the question is, how much of that do you want to write down on paper in guidelines that say, this is what we're doing with our exploitative abuse cases? We're doing politics and we're ignoring economics. I mean, I don't know. Maybe, in other words, maybe we won't see guidelines.
Sometimes borders between economics and politics are really narrow, but No, I would like to know if do you think that we can. And if you look at the United States, the debate is really, no, I don't say hold, but is ongoing. So I ask you to answer, and also the other panelists.
Yeah, it's a very good point. And it's mentioned in the communication that sets the scene for the targeted amendments. And you can find traces also in the case law that there are obviously that antitrust enforcement can contribute to consumer welfare, but that it can also contribute to other objectives. But that the goal still is consumer welfare, but there are other goals such as plurality in democratic societies, and there's a reference to the Google Android judgment, not mistaken, in the communication. So I think this is how it fits together. I don't think it's the same as for the discussion about is this not an effects-based approach anymore. I think the answer is already given, and this is an effects-based approach, and that's thanks also to the guidance paper steering the discussion that has ultimately led the court to pick up an effects-based approach. And we're just debating about how is that effects-based approach implemented. So I think these are two notions: consumer welfare, effects-based approach. They're still very vivid and still very present. And but at the same time, we cannot ignore that antitrust enforcement may also contribute to other goals. And we also need to have a more dynamic view of things when we apply the effects-based approach, and that it's not only about price and cost analysis. And I think that the judgments of the court has opened really the discussion for that, and they allow the Commission to take into account other parameters of competition, innovation, choice, etc.
I mean, I actually think we may have come in a way full circle, because if you look back to the 90s and you look, for example, at some of the speeches from Karel van Miert, he talked about the aims of competition law being broader, political and social, pluralistic democracy. And then with Mario Monti, we kind of went a bit more economic approach, consumer welfare, effects-based. But then we've seen Commissioner Vestager coming out and talking about the values that you were just talking about, fairness, pluralism, etc. So those ideas have come back, if you like, alongside the things that Mario Monti was trying to emphasize. So perhaps they're all there now.
Okay. I took the answer as a yes. So okay. And do the guidelines are going to have an impact on the national levels? I mean, we are seeing changes, many changes at the national level. I'm thinking about the German new competition law that I think is really advanced. Yeah, what the guidelines mean for the national enforcer.
I think I mean, I can only comment to the extent that the NCA in Germany, such as all the other NCAs, apply Article 102. And in that respect, I think guidelines, again, coming back a little bit from my vertical block exemption, vertical guidelines experience, national competition authorities and national courts, they typically take into account guidelines. So I think moving it away from a guidance paper to guidelines then also means that competition authorities will turn to it as what they are, guidelines. And there are many ways to engage with national competition authorities, but I also think it's a great opportunity to exchange with them within the framework of the European Competition Network. That's something very unique to the EU, and which allows the Commission and the national competition authorities to engage and discuss with one another, and to make sure that ultimately there are guidelines that take into account also the national competition authorities' views.
Yes, well, it's true that, of course, the guidelines are meant to, well, give guidance to national competition authorities and courts. But of course, we know that some national competition authorities who sometimes disagree with the guidelines and say, well, we don't need to follow them because they are only soft law. And a good example is the Coty case where the Bundeskartellamt was not really convinced by the approach defined in the guidelines, but then the court went before the case went before the German court, which referred a question to the Court of Justice, which then responded then it was case law, but gave a response which reflected the content of the guidelines. So the guidelines are also a way to give weight and credibility to positions which the Commission would otherwise take. And so when the Commission, which intervenes, of course, in every case in which there is a reference to the Court of Justice, then can present its observations, not just as being the observations that it is making in this case, but can also refer to its own guidelines to give them more weight than just statements made on the fly in that specific case.
Are there any examples of a court disagreeing with guidelines, or is it always one direction?
No, I mean, what I know, we are better, Johannes, better pleased than me to discuss this matter. I mean, that was a very public disagreement between the German competition authority and well, the view presented based on the guidelines. But then when it ends up before a court, and that is also something which is very striking since modernization, the number of references for preliminary rulings coming from national courts. So which send to Luxembourg all kinds of questions, sometimes very odd ones or very small ones. And so the court, if there is any, well, hesitation, the court will, in most cases, ask the Court of Justice, what it thinks about the issue, instead of, well, defying guidelines, for example. That's, I think, what happens in practice.
So, I mean, in response to your question, then I guess I have some concern about the extent to which there's not so much a dialogue, sort of two entities trying to interpret law that needs interpretation, as opposed to the Commission taking the opportunity, recognizing that guidance even, but guidelines certainly have taken on a kind of force of law that's the way the courts have approached them. It becomes an opportunity to, sort of unilaterally make law that is effectively binding on the courts. And the reason I think this is potentially a problem, I mean, I come from a very different legal, structural background where that's just not allowed in the first instance. And I understand that might be okay here, but I also think that it's combined with a sort of level of deference to the Commission that already exists, that it really compounds. It's like thumb on the scale on thumb on the scale on thumb on the scale. At some point, it's hard to call it anything like due process. Or I'm being a little bit hyperbolic, but that's a question, right?
But no, just to respond to this, I think ultimately it's for the Court of Justice to interpret Article 102. So you can write anything in the guidelines, but then it's the court looking and applying Article 102. So therefore, it's only guidance given by the Commission on its interpretation of Article 102. And by that, because national competition authorities and national courts look at this when they apply Article 102, it's something it's a source of reference, but it's not binding in any way, and certainly not the Court of Justice. And that's why this whole
examples of that. Where,
this whole.
where there are guidelines, where the Court of Justice has pointed to the guidelines or answered a question that is answered in the guidelines differently than the guidelines that exist, or pointed to them and say they're wrong.
It's difficult to speak about 102 because there are no
I don't-
guidelines.
With
but
101,
I don't mean
101,
to, yeah. I
you
mean,
can, of course, you can identify certain tensions between what the court then ultimately says, and then this is part of the exercise. For example, the horizontal guidelines and the vertical guidelines in the area of Article 101, they're up for review when the related block exemption regulations expire. And one purpose of this exercise is also to update. So Jean-François mentioned, for example, the Coty judgment that needed to be reflected in the new updated vertical guidelines, certainly. And there it's an update in light of the Court of Justice's judgments. And I foresee the same.
Which itself was being inspired by the then existing guidelines, the difference between the fact that platforms like Amazon, etc., could be excluded. This is something that you could read in one line of the then existing guidelines. So in a sense, but then the Court of Justice, when it does that, then gives the guideline the status of case law.
but I still haven't heard an example where the court has disagreed with guidelines.
I personally haven't seen any. I could evaluate this. Yeah, we've seen a case where the Court of Justice would have said something which is clearly inconsistent with one of the horizontal or vertical guidelines.
I think you see some tension, but it's not like I also cannot recall at this moment a case where the Court of Justice would have said that paragraph in the vertical guidelines are not in line with Article 101. I don't think there has been something like this, but obviously the court interprets Article 101, turns to the guidelines and interprets Article 101 on its own initiative or on its own motion. So I think the hierarchy of norms is clear, and I think the Commission knows that very well. And there's always, as I mentioned, there's always the risk. It's inherent in guidelines that the Court of Justice will say something different. And lawyers, obviously, when the new judgments are out, they also like to comment on judgments and identify certain tensions and argue that the vertical guidelines or other guidelines are not in line with Article 101, Article 102. As interpreted by the court. So that's also always out there.
We risk to miss the first and the last question. That is, I mean, can we expect an evolution or a revolution for the European competition law? So I would like a quick answer from everybody.
Well, the revolution took place in 2008, but, reluctantly, and what we are seeing is an evolution in that revolution.
I agree with that. And I actually would add that the 2008 guidance paper was actually a pretty bold thing for the Commission to do. And they probably took a chance hoping that everyone would come along with them. And they did, which gives us now just an evolution going forward.
Can I say none of the above? I worry that
You
it's
can, you can.
a devolution, I suppose. I think you have to look at the amendments to the current guidance paper as evolution. Right? I mean, they're very targeted, they're very narrow. That's an evolution. But especially given what we've talked about today, I am concerned that the effort is to escape some new heightened scrutiny coming from the courts. And in that sense, that's not a revolution. It's not an evolution. It's sort of potentially a return to before the revolution of 2008. Yes. So, but we'll have to see. I mean, in one sense, it's a little, I mean, we're in the dark here, right? We're talking about guidelines that aren't going to be issued for more than 2 years. And I mean, only Johannes knows what they're gonna say. The rest of us don't.
So in fact, we are concerned about the possible counter.
Yes. That's better. Counter revolution is.
I also wanted to make the discussion more interesting by saying, you say neither evolution nor evolution. I'd say, can I say both? Because evolution is, I mean, it's based on the case law. I think the case law will set the boundaries for this whole exercise. It's to some extent, it's a codification systematization exercise. So in that sense, it's an evolution. And it's also an evolution because it's the effects-based approach is now enshrined by the courts. So it's here to stay, and it's a matter of how you implement it. And it's a revolution because there will be guidelines for the first time. So I think that's a big initiative that stakeholders have also taken note of, and that will make the discussion over the next 2 years a very interesting discussion.
Thank you. Are there any questions? Oh, please.
Okay, well, first of all, thank you all for being here and for the great discussion. It seems to me that there's a running theme to this guidance paper and the policy brief, which is to somehow make it easier for the commission to bring certain cases, right? And there are two clear examples. There's the suggestion that false positives are preferable to false negatives. And another one is the as efficient competitive test. So just to stick to the latter example, with the as efficient competitive test, is the commission cognizant? So the commission says that we should be careful of a dogmatic interpretation of the as efficient competitive test, right? Okay. What about the flip side? Is the commission cognizant or aware, or does it intend to incorporate guardrails that, make sure that there's a distinction between the elimination of a competitor and foreclosure? And if so, is this something that it's already reflected and maybe I've missed, or is it something that is maybe going to be highlighted further in the guidelines? Thank you. Oh, sorry, it was for Johannes.
You're all knowing.
I would have guessed so. So to respond to the first question, I don't think when I explained, or when I mentioned the reason why the commission is now endeavoring this initiative of guidelines was increased concentration and also digital markets with all its characteristics. I meant to say that false negatives are more likely and more costly. It's not that false positives and false negatives that you should in any way rebalance it, but what we need to do, and I think this is the theme that also is very present in the policy brief, is that we need a more dynamic approach to enforcement of Article 102 and a more workable one. And that relates to the as efficient competitor test in the sense that obviously there's no systemic protection of less efficient competitors, but we've seen also, you can look this in post-Denmark too, it's a very good example. I think there are some competitors that don't have the cost structure. So if we focus too much on price and costs as a parameter of competition, then we're missing out on some other aspects which are crucial in certain markets with certain characteristics. So in terms of as efficient competitor principle, the idea is, and this becomes clear in the policy brief, at least the people that wrote it, I think are very much of the opinion that we need to broaden our perspective a little bit, take into account all parameters of competition in line with the case law. The court has opened this up. There are it's not only the recent Google Android judgment that refers to it. I think it's also in Unilever very, very clearly. And so these other parameters of competition need to be taken into account, and they need to be factored in when applying the as efficient competitor principle. Then I think what has also changed a little bit over the last years, and certainly since the adoption of the guidance paper, is how the as efficient competitor principle and the as efficient competitor test relate. And one of the, or two changes made to the guidance paper relate to one, the as efficient competitor principle. This is the idea of not only that under certain circumstances, again, no systemic protection of less efficient competitors, but in certain circumstances, it's worth protecting those competitors to gain a foothold in the market and to then long-term effectively compete with the dominant undertaking. And I think this takes into account very much the effects-based approach and the idea of effective competition being more dynamic. And in terms of workable enforcement of Article 102, this idea of the as efficient competitor test, now moving away from the as efficient competitor principle to the test, is that we know that, or the court has told us also multiple times, this is one way to assess an abuse under Article 102, but it's important to take into account all relevant circumstances. So the as efficient competitor test, if it's appropriate in a certain case, and as read or as explained or detailed in the competition policy brief, makes a lot of sense in pricing abuses. And that's where the court has also taken its position, for example, on margin squeeze cases and predatory pricing. Those are cases, price-related abuses, where an as efficient competitor test makes a lot of sense. But there are also other types of abuses where the court has clearly said that's an optional test. And I think that's a fair point. And then whatever the company, the under investigation puts forward, I mean, the Commission has to engage with it to make this assessment of all relevant facts. So I think it's much more nuanced. The competition policy brief, for good reasons, promotes a more dynamic and more workable enforcement of Article 102, and it's very much enshrined in the case law of the court.
Thank you very much. Maybe you want to ask another question? I can come back because I don't know how much time we have.
Yeah. Sorry, concerning the AAC test, I mean, I agree. This is a test for, there must be a pricing component. I think there was the example given, was it in Unilever, that if there is an exclusivity provision, but then there is a payment that is made, which is in fact a kind of rebate, then you can apply the AAC test to that. But if there is no pricing component in the abuse, the AAC test as such, I mean, makes no sense. I don't see how you can apply it. On that, I think that's obvious. Now, there is the concept that the competitor should be as efficient, but I think that this concept was developed in connection with the AAC test, which is just a procedural test. In fact, you use the cost and of the dominant company.
Good. So.
I don't know. It's. I guess I've said this a little bit, but I think this highlights it. I don't disagree entirely, but I think that to say that the Commission is looking at these cases that have been decided and incorporating those decisions, elides over a lot. There are different ways of incorporating those decisions. One way of interpreting Intel is that it's a very narrow. This is the way the Commission interprets it, right? It's very narrow. It only applies to pricing harms and rebates specifically. Another way to interpret it, though, would be to say it's not really about, it's not really about the as efficient competitor test. It's more about the as efficient competitor as a constraint, as a constraint on the Commission finding any competitive harm in the absence of any kind of real effect, consumer effect. And you could say, okay, but then they do have this effects-based analysis. They're saying, well, it can't just be rank speculation. It has to be something more than that. Except they're sort of systematically undermining the actual constraints that are more than that. They say, okay, it's not just actual effects, it's potential effects. It applies not just to as efficient competitors, it also in many cases will be less efficient competitors are also relevant here. Sorry, there's also the minor from Google Shopping about not just efficient but attractive competitors, which was incorporated in a footnote in the amendments of the guidance paper. And yet it's interesting to point to Google Shopping, which some of us would say is like the antithesis of an effects-based analysis. It is one that says here's this thing that it's an effect. We saw this deviation of traffic, but we didn't bother to ask whether that actually was something that consumers were harmed by. We just assumed that. And I mean, you could say, okay, it's not rank speculation. There's some basis for it beyond that. Maybe it's consistent with what the guidance paper or the guidelines eventually will say. But it's almost like picking and choosing the aspects of the cases that they're going to reference to find ways to avoid constraints or make interpretations that are, to their benefit. I'm sure there are exceptions to this, but that's how I see the way they've incorporated Intel and Google Shopping here, at the very least.
You want to reply shortly? Because no, it's only okay. Okay.
Maybe in the interest of getting more questions, I mean.
Yeah, okay.
We have
Any
about
question?
8 minutes left, so anybody that has any questions, I'd love to hand the microphone off to you. But do keep in mind, we will have a champagne reception after this, so if you have any burning questions you want to ask one-on-one, I'm sure our panelists would love to answer those in person as well. Are there any questions?
So maybe just one brief question on the as efficient competitor test. And I guess this is what Jeff was suggesting. I think everyone around the panel today said effects analysis is important. But it strikes me that that statement actually has more implications than people give it credit for. To me, if you say effects, what that's associated is, let's try and infer causality. And I think the as efficient competitor principle has a big part to play in that, right? Because the question that we need to be asking is, are rivals being excluded by virtue of anti-competitive behavior, or are they exiting the market by virtue of just the market function? And I think, at least in some cases, looking at whether competitors are as efficient gives you some indication. Now, and I guess this is the question, if we decided, let's stay in the extreme, I'm not saying this is what the Commission is doing, we are not now going to look at whether competitors who exit the market are as efficient. What then becomes the alternative to make sure that we get causality right and that we're separating inefficient exit from foreclosure?
Well, in the Intel judgment, one paragraph, which I think is very important, even though it's placed in the discussion of, what happened in the case, which is a pricing case, which is paragraph 139, which indicates the factors, one of which is market coverage, for example. The General Court Intel judgment said there is no de minimis for under Article 182, Post-Denmark 2 also said that. And I think that the Court of Justice made it clear that market coverage is important. You must make sure that the abusive practice covers such a share of the market that there is a possibility of foreclosure. If it is just a small share of the market, we should not worry about that. So I think that the effects-based analysis is simply, I think, a common sense approach, trying to see whether the practice you are after is a practice which really makes access to the market more difficult for competitors in such a way that at the end of the day there will be consumer harm. So whether you say capability, likely, I think these are semantic discussions. You have to see whether what you are concerned about has a possibility of real impact on consumer at the end of the day.
Doesn't almost anything have the potential for an impact? That's what worries me about this undifferentiated space between rank speculation and absolute certainty. And then you combine it with language like competitive structure or less efficient competitors are also relevant. I mean, it starts to all point in one direction rather than being describing it as sort of practical, pragmatic.
Yeah, it's ambiguous, but then there is a good example of a situation where there could not be any foreclosure Qualcomm because there was no competitor.
But that's the edge case, right? Yeah. I mean,
but the commission nevertheless found an abuse.
Fair enough. Right.
Yeah.
Right. No, that's important. I agree. Then, I think we can all be delighted that the court said something about it. But then maybe we'll see that the ECJ will do something different. But then you have Google Shopping where I think you've entered this really gray area and not imposed that kind of, and then this is not the commission, this is the court, not imposing, well, it's also the commission, not imposing that kind of a constraint that you'd like to see, sort of eliding over that, right? Maybe to the causation point, you're just inferring causation where it's not clear that you have any basis for doing so.
So I'm not sure it's a question. It's a little bit of a comment. I was involved in writing the discussion paper back in the first together with Luc, right? And we came up with this as efficient competitor test. And to be honest, it was as a way to try to address Michelin 2, right? Because everybody, I think a lot of people inside DDCOM said this doesn't make sense. It's gone too far, right? But that was what we had in mind. I think we did not have Intel rebates in mind, right? And if you read carefully the guidance paper, the whole section about retroactive rebates, it's about Michelin type rebates, right? This is basically what, in my view, if you read it carefully, that is what it's about. And then in my view, we took a wrong track with Intel, right? And I think people should think a little bit what it is about they're saying when they talk about this, if the as efficient competitor test is the thing. If you don't do that, then you are not doing proper competition policy. Do you really expect that the judge in Google now should go in and do as efficient competitor tests to the agreements Google, to the payments Google gave in order to get exclusivity? No, I mean, and I've gotten to the point where I think, I mean, if it looks like exclusivity, it walks like exclusivity, and it quacks like exclusivity, maybe we should just deal with this as if these were exclusive, dealing something similar, and then use, as Jean-François said, use 139 and look at coverage and look at what the others can do. But let's not spend like these poor people did in Intel 2 years trying to figure out how to spread out research and development costs and so on. I mean, it was a wrong track in my view, and I think, and unfortunately, in my view, the court has gone too far by this. They got very excited about this now. So we are a little bit, or the poor people who do now, Johannes and others have to find a way to roll back from that. And I think we need to roll back from that, although I am entirely for an effects-based approach. But please don't take this as efficient competitors and say, now it's there. That is anything that is not doing that full circle, right? Means we are going back on everything and can never be a proper, reasonable competition policy.
I agree, but I also think that I've always viewed it, from my safe distance, not living in the jurisdiction that covers, as more like an analogy, an example. I mean, yes, it's silly. It would be silly to say every case has to turn on an as efficient competitor test, but you could find an analog for the as efficient competitor test that actually matters in the foreclosure cases, like Google cases, right? Minimum viable scale sort of test, for example, comparison to a but for world, right? I mean, it's just a degree, I think, of empirical and analytical rigor that, that I think that's not the words they literally use, but in Intel case, that's really what they're trying to impose, or at least I guess I wish that's what they're trying to impose. But I agree, it would be silly to actually put so much weight on that one test.
One more question. It's a bit of a cheeky question, maybe a yes or no question. So we've seen case law, we've seen Google search case, Google shopping case law that will soon be ECJ case law. We've seen cases like the Meta Germany case. We've seen other cases with maybe not at the ECJ level, but where that concern firms' use of data, things like that. Is this something that we can expect? And I guess it's for all the panelists reading in the crystal ball, and based on what we've been saying today, can we expect to see that sort of case law, those sort of cases reflected in the future guidelines, or will the guidelines remain centered on mostly on what we see today in the guidance paper?
That's one for Johannes. I don't know. No, I don't want to speak for God.
Well, I think we all have a role to play in how these guidelines turn out 2 years from now. And so, there's going to be an awful lot of input. And I would think that they're going to move the ball forward.
What would be the point of having guidelines that just reflect what's in the current amendments to the guidance paper? I mean, I am a cynic, but I also think that guidelines are going to have to do something more than what we see in the amendments to the guidance paper. Otherwise, it's just such a lost opportunity, right? I shouldn't say that, because they could actually do something worse, but.
No, but just to build on this, I think what's reflected in the revised or amended guidance paper, I mean, that ultimately also has to be in the guidelines to the extent that it just reflects case law. So that's clear. And then there are other judgments. And again, there are different types of notions that play a role in the Court of Justice case law. And that gives the opportunity now to take stock and build on these principles. There's more to it than these 5 targeted amendments. That was so blatantly out of sync. So there's more to it, and it's something that needs to be reflected in the guidelines. The draft to be seen next year.
Okay, well, in that case, I'd like you all to extend a warm thank you to our panelists for a great conversation. Thanks. And there are drinks waiting for us.